Bueno, buenas tardes a todos, bienvenidos a esta presentación de este libro. Esta presentación va a ser en inglés con un PowerPoint en castellano. Así que en primer lugar voy a presentar a los expositores y después les voy a dar el uso de la palabra. So, what I've said is welcome Victoria and both Johnnies. Jonathan Hardman and Jonathan Horner. I'm going to make a brief presentation of the three of you, and then I'm going to give the floor to you. Entonces, ahora vamos a presentar en primer lugar a los editores de esta obra y al presentador de la obra The Origins of Company Law, Methods and Approaches, cuya traducción es Los orígenes del derecho societario, métodos y enfoques. Los dos editores de esta obra son Jonathan Hartman y Victoria Barnes. Jonathan Hardman es profesor titular de Derecho Mercantil y de Sociedades en la Universidad de Edimburgo, Reino Unido. Es profesor asociado honorario en la Universidad de Auckland, Nueva Zelanda, y en la Facultad de Derecho de la Universidad de Edimburgo, donde es profesor, ha sido director de Desarrollo Profesional Continuo, ha sido codirector de Relaciones con los Alumnos, ha sido director del Departamento de Derecho Comercial, director de Relaciones Exteriores y en la Universidad de Glasgow, también en el Reino Unido, ha sido profesor honorario. Su principal área de investigación son las formas societarias. En particular, su investigación se centra en las estructuras de argumentación desplegadas en el derecho corporativo. Y toda su trayectoria está disponible en la página web www.hardman.co.uk. Victoria Barnes, la otra editora de este libro, es PhD, doctora, por la Universidad de Reading, en Inglaterra, Reino Unido. Es profesora de Derecho Mercantil en la Universidad de Queen's, en Belfast, en Irlanda, Reino Unido. Es editora jefa del Journal of Corporate Law Studies y sus áreas de investigación son el derecho contractual, mercantil y de sociedades, desde perspectivas transnacionales, comparativas e interdisciplinares, en los que analiza acontecimientos históricos cruciales como casos emblemáticos y los sitúa en su contexto. Su trabajo rastrea la evolución de las organizaciones, los principios jurídicos y las doctrinas a lo largo del tiempo. Finalmente, Jonathan Horner, que es el que va a presentar el libro como externo a la obra, es máster en Derecho por la Queen's University de Belfast, Reino Unido, es doctorando de la misma universidad. Sus áreas de investigación son el derecho de sociedades y la información empresarial, y su tesis se centra en el deber estatutario de los administradores del Reino Unido de promover el éxito de la empresa y en los informes de las empresas del índice bursátil de referencia de la Bolsa de Valores de Londres y al respecto la consideración por parte de los administradores de las cuestiones sociales y medioambientales que deben tener en cuenta en cumplimiento de su deber. Así que bienvenidos a los tres. Welcome Victoria, Johnny Hardman and Johnny Horner. I'm going to let you share your presentation. Okay, so go ahead, the floor is yours.
So am I to begin then? Yeah.
Yes.
So I'm just realizing you're sharing the slides, Johnny. So can I just ask you to move them whenever I need you to move them then? That's okay. Just to clear that up. Okay. Um, so hello everyone. My name's Jonathan Horner. I'm a PhD student at Queen's University, Belfast, um, studying the intersection between director's duties and corporate reporting. And I've been very kindly asked to uh, give my thoughts, let's say, on the origins of company law. And so hopefully I will be speaking for roughly 20 minutes. And then I will pass the floor on to Johnny, and he and Vicky will discuss in more detail the process behind the book. So let's move on to the next slide then, Johnny, if you will. So I'd like to begin um, by discussing some of the context behind the book. So in Anglo-American corporate law policy discussions, there has been renewed interest in age-old, that is, historical models for regulating the corporate form. And the example I give on the slide is the recent US interest in corporate chartering, special corporate chartering systems, as a way to check or as a way to place a check on corporations. I also highlight a quote from the introduction to the book, which I think is emblematic of the key justification for why it's been done, and I will just read it out. Company law is one topic that has frequently lacked systemic historical attention, and so its historical development has usually been under-theorized. And so there's a clear need for more historically conscious work in company law as a field of study. And this book shines a light on that. There's a need for a richer understanding of the development of corporate law, the understanding that is both multidisciplinary and multi-method. And this is very much emphasized by the editors from the outset of the book. Next slide, if you could. So, what does the collection do? Again, I'm sort of taking quotes from the introduction. So it constructs a research agenda which embraces difference in a positive way. So the idea behind it is not to present one vision of how Anglo-American corporate law has evolved or has developed. The contributions within the collection cover several different areas of corporate law, canvassing different perspectives and utilizing different methodological approaches to study the history of corporate law in different areas. The collection, in doing this, promotes dialogue among legal historians, black letter legal researchers, and economics and business scholars, amongst others. And as I've highlighted, the contributions within the book have a focus on legal developments in England and in the United States primarily. But as I will speak to later on in the presentation, that does not necessarily mean that it is without worth for people from outside of those jurisdictions. But I will cover that later. If we could move on to the next slide then. So first of all, as regards discussing some of the topics covered in the book, I would like to shine a light on Johnny's own contribution in chapter 2, which examines the use of historical arguments in normative debates within company law. He highlights two main patterns of argument. Those are trajectory arguments and mistake arguments. Trajectory arguments are those that contend that company law has developed upon logical lines and should continue to develop as it has already. Mistake arguments, by contrast, contend or use historical arguments in order to contend that there has been a mistake made in the development of corporate law that needs to be rectified. Hardman clearly argues that such arguments are pliable and can be used to serve the author's pre-existing normative viewpoints. And so the piece that he contributes to the collection can be interpreted as a call for honesty as regards the agency involved in choosing historical narratives to support pre-existing normative positions. Next slide, please. So another theme within the collection is that a number of the contributions within it challenge commonly accepted assumptions about the development of company law. I've provided two distinct examples here. Wells's contribution in Chapter 4 considers the emergence of the limited liability partnership, LLP, in America. He provides the conventional view that this was a straightforward policy choice, but inevitably counters it to say that the limited liability partnership allows lawyers to maintain their individual professional identity whilst limiting their liability. So there is a need to gain the benefits which members of limited liability companies have, whilst also suiting the form to lawyers' needs, let's say. The chapters, the contributions by Lamoureux and Hilt both consider the special chartering regime system for certain US corporations that existed in the past. They consider it in different ways, but both set out the conventional view that the special chartering system was a force for public good, but counter it to say that it was actually a tool for political patronage. These pieces are especially relevant given, as I mentioned before, the recent policy interest in the US from some presidential candidates actually to reintroduce special chartering as a way to check corporations. So let's move on to the next slide then. As some of those examples will highlight, as I want to go into greater depth on, the collection has considerable breadth in terms of the topics that it covers, and I've given two further examples here. So first of all, the issue of corporate separate personality and legal identity. This is covered by Thompson in Chapter 5 with the United States focus and American focus. He considers the legal recognition of a corporation as distinct from its shareholders. He considers specifically the US Supreme Court decisions which have granted corporations rights such as freedom of speech and religious liberty. Those decisions, Citizens United and Hobby Lobby. Watson then in Chapter 6 brings a more UK focus or UK influenced common law interest into her tracing of the development of the concept of separate legal identity. She considers the fundamental case of Salmon, and then also considers a more recent Supreme Court judgment of Sequana, which has reaffirmed the separate legal personality of the corporation. These contributions can be contrasted somewhat with Talbot's contribution in Chapter 9, which is a case study of Brunner Mond Company Limited and its expansion in the late 1800s and early 1900s. and Talbot considers how the company was once very much influenced by the economic, social, political beliefs of its founders, but as it expanded, as it got bigger, as it was sold, um, the company became more impersonal. And as I said there, the chapter reminds us that a company's identity can be molded by the people involved in it, although that's probably less of the case today than it would have been back in that time. Um, there's also the topic of the nature of corporate shares and shareholder rights. Harris in Chapter 10 considers the evolution of share attributes such as transferability and liability. Shrinks in Chapter 11 conducts a comparative study of voting rights, highlighting the international emergence of the inseparability of shareholding from voting. We'll move on to the next slide then to consider probably the key theme of the collection, which is the relationship between corporations and the state. It's an ever-present theme in the collection, even if the contributors very rarely discuss it explicitly. So whilst most contributors don't explicitly deal with these issues, deal with issues of political economy and so forth, it's an issue which lingers in the background, and that's the case for a lot of corporate law scholarship in any case. Just to highlight again two particular contributions, those of Johnston and Rawlings. They highlight the role of specific state actors in shaping company law and corporate governance. Johnston, particularly in Chapter 12, discusses how the Bank of England and Foreign Committee played key roles in entrenching shareholder primacy in the UK, whilst Rawlings in Chapter 13 revisits the UK government's shifting view of hostile takeovers in the 1950s. And both emblematic of this corporations and state issue. So we'll move on to the next slide then. So I think it is fair to say that the collection is quite varied, it's quite eclectic, and I don't mean this in a negative sense in any way. The contributions cover a broad range of topics and utilize broad range of methods and a broad range of data. And that's not a negative because to reiterate, the goal of the book is not to present a linear historical narrative that is faithful to one methodology or subset of methodologies. So the collection's broad coverage is arguably its foremost strength. The collection emphasizes areas of company law whose field of scholarly inquiry could be enriched by historical research, and it highlights the various ways in which this research can be done. And in that way, it can be sort of seen or can be viewed as a guide for researchers to see how they can develop the historically conscious corporate law literature. And I think it's not mentioned in the slide, but I should mention it in any case. Wilson's contribution in Chapter 3 of the book, her law and history methodology, which is conscious of the interconnectedness between past, present, and potential future corporate law developments, is a very interesting read, and specifically a methodological approach which one may adopt to advance the literature, I suppose. Shall we then move on to the next slide? Okay, so just to touch briefly on the limitations and scope of the collection, I would be remiss if I didn't mention that the editors very clearly highlight both of the things that I'm going to say in the probably both in the introduction and in the epilogue to the book. So this is not really a criticism. It's just something I feel like I have to mention. So the vast majority of the book's contributions rely on qualitative research. I think that's just reflective of company law research in general in a lot of ways. But the editors note clear potential for quantification in the discipline, for quantitative approaches in the discipline. And I think this is pretty well exemplified in chapter one's blending of quantification and case study method in the study of the historic cases cited in 5 leading company law textbooks. And the authors use that quantitative study to develop a novel typology in which to categorize historic cases from those that are forgotten to those that are landmark or seminal, I should say. And then second point, as I've already mentioned, the collection focuses on English and American scholarship, legal principles and issues. But as I will sort of really emphasize in the last slide, that doesn't mean that it's not worth reading for those that are outside of those jurisdictions. Next slide, if you could, John. So this is the final slide. I realize I've gone quite quickly, or more quickly than I had anticipated, but that's good. So just to finish off, on the point of the focus of the collection on English and American scholarship, I would argue that any reader with an interest in company law will be informed by the collection, regardless of which jurisdiction they come from. The book's contribution, after all, is arguably not in the specific topics and issues engaged by its contributors, but is rather in its in the stated general significance of historical research in light of current policy discussions, as well as the conveyed need of a diverse range of disciplinary perspectives and methodological approaches to such historical research. And as such, the origins of company law is a significant contribution to corporate legal scholarship. Not only does it comprise a collection of insightful historical studies, but it also represents a justifiable call for scholars to develop a deeper understanding of how company law came to be, and to use that understanding in order to inform discussions concerning how it might yet evolve. So the focus of the collection is very much in the past, but it's very much of contemporary significance. And with that, I think I'll hand over to Johnny.
Thank you very much, Jonathan.
Jonathan, thank you very much, Jonathan Horner. And I wanted to let you know that we have only a couple of minutes to finish this block of the Zoom. So what we are going to do is we are going to get out and then re-enter so as you, Johnny, and Victoria can present, okay? So with the same link, we will re-enter in a couple of minutes, okay? Entonces, como se está terminando el Zoom, vamos a hacer como hacemos siempre, salimos y volvemos a entrar con el mismo link, ¿ok? Entonces nos vemos en unos minutos, gracias. See you in a couple
Perfecto, gracias.
Bueno, continuamos entonces con la segunda y última parte de la presentación de esta obra. Ahora se van a referir a ella los dos editores, Jonathan Hardman y Victoria Barnes. So we are going to continue with this presentation, and now it's a time for Johnny Hardman and Victoria Barnes, who are the co-editors of this book. So the floor is yours, Johnny, Victoria.
Brilliant. Thank you very much. Well, to everybody, to Jonathan for engaging with our work. It's always nice to listen to somebody talk about your own work. It's very, very surreal on that basis. But also to Viviana for reaching out and arranging this for us. We really, really appreciate it. It's wonderful to be able to discuss this to a wider audience, and to everybody for joining us. You never feel quite as foolish as a British person as when you speak to people who speak better in their second language than you can in your first. So thank you very much for listening to us. So I want to move on to the process of the edited collection, because this was a slightly unusual one, and it was the start of something really quite special. Vicky and I now collaborate quite a lot, and it was through this edited collection that we met. At the time, Victoria was the convener of the legal history part of the Society of Legal Scholars. That's the main UK academic legal society. And I was incoming as the equivalent in the company law section. And Vicky and her co-convener of legal history had a wonderful and slightly off-the-wall idea of connecting our two sessions together. And I was very keen to do so. And so from there, we obtained funding to have the main event of the Society of Legal Scholars, the annual seminar on the interaction between legal history and company law. And we held that in 2022 in York. And so from going from nowhere at all to suddenly having this prestigious event was excellent, but also quite terrifying, because we then had to fill it and find people to speak at it. And so we worked out together the best of all of our contacts and pulled them all together and approached them, and very luckily people said yes. So at the seminar itself, we had some of the leading Anglo-American scholars who look at corporate law, who look at legal history, who look at business history, coming together to discuss. And at the conference itself, we had a series of papers that didn't really speak to each other. Everybody presented their own interest, and there wasn't that much cross-connection between them. And so it was quite interesting, the process between the initial papers and what now appears in print. Because at the same time as we were organizing the conference, we put the book proposal in based on the back of the conference papers, or the abstract for the conference. And we realized shortly afterwards that actually it wasn't that appropriate. They were so different that we had to pull them together quite a bit. And so we gave authors a long time after the conference, a year, to finalize their own chapters. And then Victoria and I had to sit down on calls like this with various chapters open to work out how we could get them to speak to each other. And even though it was a slightly long process, I think the end result is quite strong. So I'm now going to pass over to Victoria to talk about a couple of things, and then I will come back in a few minutes.
Thank you, Johnny. Victoria, go ahead.
Thank you very much, Johnny. And if I can just echo my thanks, or our thanks, to Viviana for inviting us, and to Jonathan for introducing the project. So one of the methods that we thought was in the book, but we could do more with, was archival research. Only 2 of the chapters really engage with archives. And of course, this is Andrew Johnson's chapter and Neil Rolling's chapter, and they're very much derived from the Bank of England archives and the National Archives, and both of the authors there have done a lot of work. But one of the things we were surprised by was there wasn't more engagement with archival research. For historians are always using archives. And there's plenty of archives that can be used to study company law, in its doctrinal sense, to see companies in the courtroom, but also to see corporations and corporate governance by looking at business archives. So we think there's a lot that can be done moving on from this project, furthering that method and using that method to understand how historically companies have been regulated and also how they grew themselves. So the legal archives are the court archives. They're for us in the UK, in the National Archives, and some of the courts have still got their own archives, but business archives are plentiful. Most big businesses have an archive, and you can usually access it as an academic researcher. So we think this is a really fruitful and interesting area for future research. But one of the things we've noticed is how time-consuming archival research is. And both Andrew and Neil will say how long they spent in the archive to find the documents that they found. But also one of the challenges is for people to know which archives contain what. So you would go to this archive to that, or this archive. And some of this really is tacit knowledge. It's things that are hidden and you have to ask and find out. So that's one of the things we wanted to do with this project, was bring that scholarly community together to talk about where you could find this information and what other research could be done. And so that ties very neatly to Johnny. Sorry, would you press the next slide button? So this really was a very, very interdisciplinary collection. We had scholars from completely different traditions, completely different backgrounds. We had bona fide historians, but people that would never consider themselves to do historical research. We had people who thought they were lawyers or legal academics, and people who were situated within a business school or an economics department. So very, very, very different traditions, very different literatures. And this was one of our challenges as editors. Johnny and I worked quite hard to make sure that there was a melding, a bringing together of these different literatures and methods. And that was our challenge. We had people who perhaps just didn't know that the other literature exists. And they didn't know that their subject had been written on by an eminent historian using a totally different method, and vice versa. But what we found with all of our participants is they were really willing to engage with each other. And that was a really, really pleasant thing. The challenge didn't put anyone off. They were very, very keen to listen, to ask questions and to discuss. And I know some of the contributors who were on very related themes did take up those discussions. And I think that was one of the ways, having the conference, having the discussions, having that sharing of papers, that was one of the ways in which we built up those really, really strong links between the contributors. And I'll pass back to Johnny now to round us off.
Thank you very much, Vicky. I want to finish with a couple of thoughts, musings that we've had as a result of the entire process. The first, these both relate to research methods and that interesting development that Vicky identified that we saw in a number of our scholars, and I certainly saw in myself as we moved towards active interdisciplinarity. The first is a reluctance in lawyers in particular to write about their own research methods. Lawyers seem quite scared of writing about why and how they do their own research. And I wonder if part of that is that that method is just seen as very true, automatic, axiomatic, no space to do anything else. And if it's like you wouldn't start every article writing about the sky being blue or the basics of law. Some things are so automatic that they become so deeply ingrained, we often don't pick them up and start from that. So it could be seen as no need to focus on the method because it's so obvious. But it could also be, and I spotted this in myself, a bit of a fear that somehow you're doing it wrong, that somehow the thing that you've done so far, you've accidentally doing rather than deliberately doing through a reasoned method. Or perhaps a fear that, especially for more unusual research methods, that method could be stolen. And as this was an interdisciplinary collection focused on company law, it did raise some interesting questions for law as a whole. Is corporate law an autonomous unit of study or not? Does it have its own methodology, or is it fundamentally connected to other areas of study with other methodologies? That could be law, private law in particular, or it could be business studies in a wider sense. But either of those would make company law, corporate law, not particularly its own thing. It would just make it an application of other subjects within a particular area. If it's an application of private law, then it's private law applied to the company. And if it's an application of business law or company area, then it's just that applied in the legal space. And so after all of this work on company law itself, I'm less certain personally that it is an autonomous thing than I was when we first started doing it, or when we first started to connect together the two definite areas of company law and legal history. And on that note, we'd like to say thank you very much. This ends our part of the presentation. Thank you.
Oh, thank you. We are the ones who have to thank you for this wonderful presentation and for this wonderful work. Te estoy diciendo que nosotros somos los agradecidos a ellos por haber hecho la presentación, and especially for accepting to present your work to this multilingual audience. We have researchers here from Argentina and from Brazil and from many other countries. And it's been very friendly the way you presented, speaking in English and with the PowerPoint in Spanish. No sé si tengo que traducir para los demás, que resultó bien esta combinación de que hablen en inglés y presenten en castellano. Although I believe, I'm not sure whether with this Zoom, right now you can speak in Spanish, in English, and then have the subtitles during the presentation, but I'm not sure whether we can have this with this free Zoom. No sé si esto del subtitulado abajo está permitido en estos Zoom gratuitos. But anyway, now the presentation is open for questions and commentaries. ¿Alguien quiere hacer alguna pregunta, algún comentario en castellano o en inglés? Si quieren levantar la mano, si quieren hacerme señales desesperadas. Bueno, so far I haven't seen any hands raised, so I have a couple of commentaries about your work. It's so interesting. It's very, I think it is a starting point for future research. Creo que es un punto de partida para futuras investigaciones. I wanted to highlight the comparative perspective that I think is one of the axes of this book. Because we legal historians are very concerned about legal history in a comparative perspective. Nosotros los historiadores del derecho estamos muy preocupados por la historia del derecho comparada. And this book is an example of that. And I think that it is very valuable too, because it strengthens, it makes strong the relation between legal historians and those lawyers that come from the litigation and legal practice. Es una combinación entre los historiadores del derecho y los que ejercen la profesión en el derecho mercantil. And this is a battle that legal historians have been fighting for some decades, for last years, that legal history is very important because it is not research about the past, but it is research about the future. Que nosotros los historiadores del derecho decimos que la historia del derecho el pasado, sino que es investigación para el futuro. And we also put the stress in the fact that those lawyers that are dealing with the practice of law, for example, litigation, need the focus or the view of we legal historians to try to go ahead and be apart from those dogmatic visions that are so common between those who are not familiar with legal history. Estoy diciendo que la historia del derecho sirve para superar visiones dogmáticas que tienen los comercialistas o los civilistas. En ese sentido, la historia del derecho sirve para eso. And then I stress a lot the fact about the method based on archives. I consider myself a legal historian that has developed most of my research in the archives. So I give a very high value to the work with archives. But not all the researchers can work with archives because not everybody likes to research on archives. Digo que no todos los historiadores, lo digo siempre, no a todos los historiadores les interesa trabajar sobre archivos. Hay que tener una personalidad muy especial para trabajar con archivos. You have to have a special, you should like a lot archives to be a researcher of archives, because you can spend months looking for that data in a paper, in a document, and maybe you will never find it. So you must be patient, right, to be a researcher of archives. So that's why I value a lot the work of those who have written their research articles or contribution based on archives. Estaba diciendo que los valoro muchísimo. And one of the last slides that Johnny Hardman presented about the fact that you have this doubt about whether maybe some researchers don't want to share their methods, maybe they are jealous, or they are they afraid that they see other researchers as threatened, right? I think that one of the explanations to this is the fact that many researchers that are devoted to commercial law or civil law base their work in an exegetic method and not in a method based in archives. I think that that is one of the reasons maybe for this distance between them. So thank you, Johnny, for the invitation. We are willing to make joint projects. Les estaba diciendo que lo último que dije es que muchas veces los comercialistas o los civilistas son un poco egoístas de mostrar sus métodos porque muchos no trabajan sobre archivos, trabajan sobre el método exegético y tal vez no tienen tantas cosas en común. Y Johnny Hardman ahí puso una invitación a hacer trabajo conjunto para todos. I guess the invitation is for everybody. You know that our institute has, how many members do we have, Leandro? ¿Cuántos miembros tenemos en el instituto más o menos? ¿Te acordás cuántos son?
100.
100 members. Okay, we have maybe nearly, I think maybe we have 60 or 50 members, but these presentations and these lectures that we share every Thursday, as I told you, they are loaded in our YouTube channel. So the possibility of other researchers to be interested in any project is open, because they can watch this presentation, and if they are interested, they can contact us and we can provide your email address and all your contact information. So thank you, everybody. Thank you, those who were part of the audience. Thank you, Victoria. Thank you, Johnny Hardman. Thank you, Johnny Horner. I just want to thank you again and hope that we are going to be able to share new projects. And I'm going to give you this last minute also to say goodbye.
Thank you very much. It's been a really wonderful experience for us. Well, for me, I'll only speak for myself. I won't speak for the others who will speak after me. Thank you very much, and I really hope to see you all very soon. Thank you.
Thank you.
Yeah, if I could thank you all for listening, and thank you again, Viviana, for the invitation. It's been brilliant to be here and brilliant to talk about global legal history. And as Johnny says, if you are writing on this subject and you have research that's relevant to commercial law, please do get in touch with us. Johnny and I have a book series on global studies in commercial and financial law. I'll pop the link into the chat. And that's something we're very, very keen to encourage historical approaches to global and historical approaches to commercial and financial law. So if this is something that you're working on, please do get in touch. We'd love to hear more from you. Thank you.
Okay.
Yeah, thank you everyone for listening. It's been a very unique experience for me, I can say that. But thank you very much, everyone.
Okay, Victoria, I wanted to let you know that I've worked, or I'm still working about the circulation of ideas, of legal
Brilliant.
ideas. Yeah, and I've worked a lot, and I've used as a source of research doctoral thesis of the University of Buenos Aires during the second half of the 19th century and the first half of the 20th century. And one of my last contributions that I hope is going to be released in a couple of months is about the circulation of ideas in a thesis, doctoral thesis about commercial law.
Fantastic.
Yeah. Okay, so I will let you know when this will go out of print. And les estaba contando a ellos que yo trabajé, ¿te acordás, Leandro? En las jornadas, un trabajo sobre la circulación de ideas en las tesis doctorales sobre derecho comercial. Así que les voy a avisar cuando ese artículo, con suerte, sea publicado. So, let's keep in contact. We have many things in common. And thank you again. And I hope to be in contact soon with the three of you. Okay? Bye. Bye.